After Haley Olsen was arrested in Idaho for possession of marijuana, she consented to a search of her phone in the form of an extraction. An extraction makes a digital copy of the entire contents of the phone and stores it digitally. Olsen's boyfriend, Tyler Smith, was a deputy sheriff with Grant County in Oregon. When the sheriff at the time, Glenn Palmer, heard about the arrest, he became curious about whether or not Smith was involved in any illegal activity. Sheriff Palmer thought that the contents of the extraction would likely answer that question. This week, I want to discuss Olson versus County of Grant, a 2025 Ninth Circuit Court of Appeals decision involving cell phone searches, Fourth Amendment violations, and qualified immunity. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. Sheriff Palmer wanted to ensure that the phone taken off of his deputy's girlfriend while his deputy was not present for a drug offense in a different state involving drugs that were legal in Oregon didn't contain anything the sheriff may need to open an investigation for. So Sheriff Palmer decided to contact the Idaho State Trooper in charge of the investigation and ask for a copy of the extraction. The state trooper declined the request. Good job, Trooper. Sheriff Palmer then reached out to Jim Carpenter, the Grant County attorney, and asked Carpenter to reach out to the Idaho prosecutor for a copy of the extraction. Carpenter's plan was to ensure that the phone taking off of the deputy's girlfriend while the deputy was not present for a drug offense in a different state involving drugs that were legal in Oregon didn't contain anything that would require placement on the Brady list. Carpenter reached out to the prosecutor, and the Idaho prosecutor sent a thumb drive containing the extraction. Carpenter reviewed the materials and, after finding no relevant Brady materials, reformatted the drive, erasing the contents. But this is where the stories don't add up. Carpenter said that he never showed or offered to show Sheriff Palmer the contents of the extraction, but Sheriff Palmer said that Carpenter asked him twice if he wanted to view the contents. But disturbingly, Olson began to hear rumors around town about nude photographs of her in circulation, and everywhere she looked, the rumors seemed to point back to the sheriff's department. One sheriff's department employee even told her, quote, "Heard there's some pretty smoking pictures of you going around the sheriff's office," end quote. Keep in mind, the population of Grant County, Oregon is around 7,000 people, so word probably travels fast. Olson sued Sheriff Palmer, Carpenter, and the County of Grant, alleging a Fourth Amendment violation. The court found that although Sheriff Palmer asked Carpenter to get the cell phone data, he didn't get them himself, and no evidence was presented that Sheriff Palmer viewed the contents himself. As for Carpenter, he was able to receive qualified immunity, since the law on this topic was not previously clearly established. But the court did find that Carpenter violated Olson's Fourth Amendment rights, and here's why. 1. The consent form that Olson signed specifically said that the extraction was for the Idaho State Police. Nothing referenced transferring the materials to another agency, much less one out of state. And 2, the privacy of Olson's phone extended to the cell phone extraction. Therefore, another agency viewing the materials for separate reasons needed to adhere to warrant requirements, which they certainly did not here. Searching someone else's phone without a warrant or consent because someone imagines there could be potential evidence for an internal investigation would be obviously wrong. The court established that the cell phone extraction data has those same protections. For law enforcement here in the Ninth Circuit, this means you need to be careful about sharing cell phone extraction data with other agencies. Another agency doing a separate investigation might come asking for your data if you recently did a consent extraction, but the suspect is entitled to the same Fourth Amendment protections. And unless the language of the consent form says something about reserving the right to share the data with any other law enforcement agency in any jurisdiction at any time, you probably shouldn't share the data without more. If you have any questions or comments on this topic, please leave them in the comment section down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.
Negative.